Good afternoon, everyone, and welcome back to another episode of Speaking Legally, where the legal meets the cultural. We thank you for tuning in each and every week. We thank you for even sharing the broadcast with those in your network, where you have two legal experts with you every single week, 4 p.m. Eastern Standard Time. Edward Pichado Esquire and Royce Russell Esquire. My name is Dr. Stacey N.C. Grant, and I have the pleasure of producing this show each week so that we get you the information that you need. We're seeing a lot transpire in real time. We know yesterday was the anniversary of losing George Floyd to that horrific murder. And there were so many wishes going through the internet. His foundation is asking for advocacy around how do we not just let this moment in time go by, but to actually see change happen with legislation. And his family has been asking for everyone to just really keep the peace and continue to push for what is right. So we definitely want to start off the show with acknowledging that Mr. Floyd is watching us from above. Hey, Deborah. Hey, Richard. Thank you so much for tuning in today. So I will be here in and out of the show. So let me just tell you, Rich, Deb, here's the deal. Hey, Kevin, good to see you. My baby, my youngest, Old Man Jenkins, for those of you that follow me, today's prom. So mommy has to do producing duties and mommy duties. So if you see me tip out for a minute, I'm still here, but our co-hosts have a lot to talk about today. So you definitely want to lean in as I turn it over to them to give their greetings, and I'll be right back. Over to you, Mr. Pichado.
Hello, everyone. Good afternoon. Buenas tardes, todo el mundo, mi comunidad, mi gente. I'm glad you're here today with us. As usual, you're going to find this show fulfilling, relevant, and definitely educational. The content that we're going to be discussing is definitely related to this brother's death and the issues that have surfaced as a result of it. So I will ask you to stay tuned. Brother Royce.
Hey, welcome everybody. I'm just looking at my notes as we go through for today's show, making sure that everything is on par. As you know, it's the 1 year anniversary of Brother Floyd's death. There are many other folks who have suffered death at the hands of the police. I would be remiss if I didn't mention Kowalski Trawick. His anniversary was just this past April. A young man here in our tri-state area who died at the hands of the police. There are subject matters that we talked about early on in our show and a couple of series before that we're going to circle back. One has to do with, qualified immunity and what the Supreme Court is going to do with that. The others have to do with 50A. And we all know that with 50A, that was the groundbreaking, or was supposed to be the groundbreaking legislation where the public could get information about officers' misconduct in their area, and any disciplinary actions would be made public, and which can help other future litigants when they bring cases before the court. And how is that all shaking out? And then, as we discuss, we discuss how people of color was being treated by the police, and how the legal system was going to treat those same brown and black folks when it came down to protesting in the street, either under the guise of Black Lives Matter or just community protests, because of the deaths that we've seen throughout the United States. How were those people going to be treated? Our people going to be treated versus the people that stormed the Capitol? Would there be the same playing field? Would one playing field be uneven? How are they being treated? How does the legal system view them compared to how we view them in our community? So, that's what's on the deck today. And we got a handful and a mouthful. So I'll let you start off, Brother Pichado. What subject matter you want to hit first?
Well, we're gonna hit how the Department of Justice is treating protesters, and then how they're being treated, the insurrectionists as well. But I do want to mention briefly also that, and for the audience, that on May 31st will be the 100-year anniversary of the Tulsa, Oklahoma massacre, the massacre that took place. We're talking about Black Wall Street. Okay, so I want folks to keep that in mind because that's coming up too. But getting back to the related matter, right now, the Department of Justice is using a civil rights era law that was created during that time period to try to stifle the civil rights movement at that time. Because during that time, like now, you have like mass protests. You have people of color asserting their rights and being asked to be treated like human beings. And so they're out there protesting. So the federal government comes up with a civil disorder statute, 18 USC section 231, which makes, civil disorder a felony, which carries 5 years and a fine.
Now, can I stop you there as you go along? I just want to tease it just a little bit because there's a lot to chew off on this, and you and I we've had this discussion, right?
Yeah.
You mentioned the motivation. The motivation of this act was to make sure that civil rights leaders, the Malcolm X's, the Martin Luther Kings, the Marcus Garveys, in our era, the Fred Hamptons, in our era, Bobby Seale, the list goes on, would stay quiet, right?
That's right.
We want to isolate you. We want to make sure that you get the heavy hand of the law, so you keep on acting out, right? And so they came up with the act, as you said, the Civil Disorder Act, right? And I just want to make sure that we squeak this in. The penalty is up to 5 years in imprisonment, right?
Yeah, so it was actually called the Civil Obedience Act.
The Civil Obedience Act, right? And they kind of lay it out with civil disorder, right? So that's the term that they use, right? So they look for civil disorder. And as you were saying, the motivation of it was to isolate leaders in our community. That was the motivation. I'm going to read into the motivation of it. I haven't read that was the motivation, but I believe that was the motivation.
The timing.
The timing of it, right? I mean, it makes sense. So that's back then. Now, this is something that we always talk about in the show. There are laws that is on the books that we forget. We forget that even exist. We don't even write it like jaywalking.
You're like, what? I gotta take a look at that one again.
That's right.
Let me make sure my joint is updated. That West has it. Has the latest amendments.
Like, yo, really? That joint is out there. Like, word. So as we say, it's out there, and it gets dusted off when necessary. And so here we are, as you said, time of what they appear to be threat or what have you. And now here it is. But I just wanted to lay the foundation where it was dormant. Now it's being used, and you may continue.
Now, what the word is that they're using that same law to now apply to these insurrectionists. Okay, these people who defiled the nation's capital. They're using the same statute. So now they're trying to pretend that, look, we're treating extremists on both sides in the same way, on the right and on the left, which is at the end of the day completely disingenuous. You and I both know that the protest by one and the other is completely different, if you will. It's disingenuous. It actually reminds me, a number of years ago during the time of Citizens United and cases going to the courts regarding, dark money from conservative groups to conservative causes. And the Federal Election Commission was trying to find out, well, who are these donors? And guys like the Koch brothers said, wait a minute, time out. What happened to NAACP v. Alabama? Now, what is NAACP v. Alabama? That was basically a Supreme Court case that prevented the state of Alabama from forcing the NAACP to reveal its membership list. Why? Because the NAACP was saying, hey, wait a minute, if we give your list, if we hand our membership list over to the government, those people who are on those lists will definitely be subject to harassment, if not harm, and on top of that, death. Because during that time, of course, anybody in those southern states that was a member of the NAACP, more than likely they weren't going to be living for very long. All right. So these conservative donors invoked that law to prevent their names from being revealed as donors to these conservative causes to the Federal Election Commission. And
Hey,
basically, that's what this reminds me of.
I would tell you, Ed, right? As much as I despise that, right? And as much as we know what we see, right? It doesn't sound good. It doesn't feel good. Fair play is fair play, right? If the KKK wants to have a march and they want to come down the street and they want to say what they want to say, we have the same right to do the same march. It doesn't feel good. It doesn't seem right. And we know that there's some manipulation, but in so many cases, in so many places, the law is there to manipulate, pro and con. I don't like the fact that they're taking someone who's protesting Black Lives Matter based upon the deaths that are happening, and they're standing in the street. They're not throwing a rock into a police car and setting on fire while police officers in there. They're not punching a police officer in the face, stepping them, taking their gun and shooting them, macing them, coming with their own gun. I'm not seeing that. But yet I'm more upset about this, that I'm not seeing that, and yet I'm still getting the penalty of civil disorder or the Civil Disobedience Act, which still can penalize me up to 5 years in imprisonment. I'm still subject to that. But then I got the insurrectionists who are taking guns away from police officers, who are beating police officers, who brought their own guns and their own weaponry. And then you want to tell me that we both start out at the 50-yard line.
I mean, listen, for me, brother, it's a case of false equivalency. You taking situations and flipping them into, well, they're the same, when you know deep down inside they're not. What you're trying to do here is just, come up with something to say, hey, listen, it's like you're Mr. In-Between here. And you know what happens to Mr. In-Between during any war? More than likely, something's going to happen to him because he's in the middle.
Look, I don't like it, but you and I are litigators. You know you taking the law and you use it to the advantage that you have.
Hey, listen.
No, but wait. The bigger social comment and problem and cultural, where the cultural meet the legal here today is that we need to know what's on the books, right? Or we need to shout out that, hey, man, this is hypocritical. How can you take someone who's protesting in the street with flags and banners causing no harm and make that equal to someone who destroyed the Capitol? I get you. I'm with that.
And listen, there's another danger or concern that I have here, because in a little bit of my research, I also saw that there's a related statute, 5 USC 7313, which kind of speaks to an ineligibility to hold government office upon conviction. So, because, in many cases, a lot of our leaders are forged, future leaders are forged during these moments of protest.
Right.
You know what I mean? And someone being
that's where they get their teeth. That's where they get their teeth. And now
exactly. And in most protests, there are an adequate number of local laws that can deal with that situation. If in the event that local authorities feel like they have to impose some sort of rule of law to prevent things from getting completely out of hand. And you saw yesterday, mayoral candidate Sean Donovan got arrested. Look at him.
Yes.
Look at him. He's letting I'm down.
That's his Obama side.
Yo estoy aquí, bro. El que vea contigo va a bregar conmigo.
Yeah,
that's the message he's sending out to the peoples. So, hey, I got to give Sean Donovan his props, man. I'm going to look at you more closely.
Yeah. You're still looking at with your eyes closed. So I don't know how close that is.
I got the ranked choice voting. I could at least mark it down, right. Give you a little, a little.
Y'all alone for a minute.
Go ahead and go right there. Look. And because you said that, that's what we call, look at what I'm about to do, a low blow. I'm out.
well, yo, listen. I think it was last night, the New York City Board of Elections approved the software. So you will get a computer count now. So, hey, things are moving in a certain direction.
I was
I'm
happy to hear that. I was happy to hear that they got that. I still have a little concern with the education, but at least we got the software. I'll give you that.
You should have the concern because nobody buys the first electrical car. Nobody buys the first non-driving car. Ed is over there. He's doing that false equivalent on the air right now, kind of throwing it out there to wave his point.
Why we gotta go there?
He's the first one that didn't buy the first iPhone. He waited. He told his kids, let's wait. Okay, now let's buy.
I ain't wait on that vaccine though.
That's a whole nother situation.
I said I'm going over there. Give me my shot, puppy.
but back to the point of trying to equate the two agendas, number one, and therefore penalties, number two, actions, number three. I think we should be outraged and there should be some protest or some conversation about that. It shouldn't just happen in the middle of the night. And that's what's happening right now. It's happening in the middle of the night. Now, I did mention that the punishment could be up to 5 years. I want to make sure that people leave with the right word in their head, because sometimes we say things and people walk away with a different, right? They leave, they hear the 5, right? Oh, you get 5 years for it. And as you said, no, it's up to. So that means up to means that they're starting at a 0. That could be probation and keep on walking, and you get up to. So when the media starts, oh, they could be facing 5 years. They could be facing 5 years. But what's the other side of the 5 years? They could be facing no years.
And a fine, right?
And a fine, or community service, or something of that nature. So,
but you know what? A felony is a felony, Papi. Nobody wants a felony.
That is true.
It's the Papi for me.
But here's the other issue where the culture and the legal meets, right? If my brother man gets a felony and I get a felony, it weighs differently.
That's right.
Right?
That's right.
He got a nice little, loose chain around his neck. He could put it underneath his shirt. I got the big fat rope chain that you could see right through my shirt. You know what I mean? You can see it, right?
That's right.
And so we need to be cognizant of that. And, but that's the way the laws are written. And that's the way folks are going to use it to their advantage. And that's some of the things that we should be speaking to the legislators and say, look at this.
And the important thing to keep in mind here is that now that Biden is a president, pressure can be placed upon him to then pressure the U.S. attorney, the attorney general, his appointee, right, to then say, you know what, this DOJ is going to do things a little different, because I believe that policy was started by the previous DOJ. And so hopefully, there'll definitely be a change of course or course correction, if you will, with respect to this. I don't know if you're ready to kind of move on to this other topic here.
Well, yeah, I mean, I just saw a comment. I think D on the chat line said same crime, different time. And I want to say I understand what she's saying, but then I got to be careful because it's not really the same crime. If I'm protesting because you're killing people in the street and I don't harm anybody, I don't assault any police, I don't do anything of that nature, and then I have people that are running up the Capitol and they're assaulting police officers and they're hurting police officers, it might be the same slight motivation, the need to protest, but it definitely ain't the same crime.
Yeah, I mean, listen, and in all fairness, I think that civil disorder statute is being used on certain protesters that possibly did a little bit more. Yeah, a little bit more. My issue though is that the equivalency there and purpose. To me, is important, especially if you're looking to evoke federal statutes, because that incident at the Capitol was clearly, I mean, there's to what was going on there. But enough about
once it's in the Fed's hands, there's very little, they're very room for discretion. You know what I mean? That's the problem. That's
no. And I understand that the feds, in terms of enforcement in the field of law, is usually looked upon as the gold standard in terms of application and interpretation. Fine, good on that. But speaking of the feds, we got a little problem out in Long Island, out in Nassau, Suffolk County.
Well, we already know you don't want anything to do with Long Island and Nassau County as a person of color. I'm sorry to say it.
Oh, but you got,
when it comes down to criminal justice and it comes down to federal court and it comes down to state court, that's a different mindset. So I am not surprised by the information that you're about to share with the audience. I'm not surprised.
Well, you know what we recently saw in a Newsday investigation is that federal courts in Suffolk and Nassau County, when it comes to these police misconduct cases, and this is after the repeal of 50A. For those of you that don't remember or don't recall 50A was a law that basically prevented the disclosure of, police disciplinary records and associated records. And so that was recently repealed earlier this year. So the New York State legislature spoke loudly and said, look, we no longer want the public from being prevented from seeing what goes on with these officers, whether they've had previous write-ups, disciplinary matters, accusations of excessive force, etc. And so what's happening in these police misconduct cases is that the police departments in Nassau and Suffolk County, when they get sued, they will, during the discovery process, ask the court to grant a confidentiality order. That's basically a gag order preventing the public viewing revelation of the accused officers or the department's disciplinary records. And many are seeing this as a way by which these police departments are getting around the repeal of 50A, because it's not just a matter of, say, we have to have a confidentiality order because the police officer's home address might be there, or his date of birth, or his social security number. Those are things that you can redact with some effort. They're trying to claim that, it makes for a smoother discovery process. And in fact, you have lawyers saying, listen, this is being done over our objections. We are not agreeing to these confidentiality orders. From what I understand, many attorneys representing plaintiffs will agree to the confidentiality orders because for them, the case might not be, monumental enough for them to slow down the discovery process. But if the plaintiff's attorney says, I want these records to be viewed by the public, then then it should be allowed, and the confidentiality order shouldn't be granted over their objections. What say you?
I agree with you in part, and it sounds like I'm a Supreme Court justice, denied in part and granted in part. I agree with you,
Mr. In between. See
what I mean? No. So let's see what in between looks like, right? Let's see what in between look like, because I personally like the color of gray, and that's between black and white. So you know what I mean. So let's see what it.
I thought it was red, Poppy. What's going on, man?
I don't know anything about red, Poppy. But let's talk about this. So I'm in the courtroom.
OMG.
I'm waging this battle, and I got a client. My first obligation is to my client. I can't spend time necessarily arguing for the rest of the world. I mean, that's real talk, real time, real issues, real return on investment, real decision making as to whether or not they're going to hire me again. So it is hard on the litigator to battle in two fronts. First front, I don't want to sign the confidentiality agreement because I want the public to know. And so I don't want to sign it, and I wage that war. Downside of that is that you may have a client that says, can you please sign that so we can get on with my case, right? Now, I'm not saying that's the right view, but it is a realistic view that we are confronted with every day. So then I say to myself, hey, where's the advocacy group that does not necessarily have one client, but who represents society, represents people of color, represents victims of police brutality, that says, you know what, we'll file a lawsuit and we'll discuss those matters that are trying to slow up the information from going to the public. Because as litigants, you and I both know, we want the information for our case. And it would be helpful to put out there in the community for other cases. But our first obligation is to our clients, so we need that information. So this is my way of saying we probably need some more forces that'll help us get to the bottom line of making sure that the public gets that information and not leave it totally at the doorstep of the sole litigant that is representing that sole client to get that information in a way that the public can get it. Now, I'm not saying lay down and don't fight. I'm just saying that's the reality that society doesn't know that we have to face in reference to get some of the records and move on with this case versus get the records and be able to reveal it to the public. And if courts are stifling that, process, then they need to be held accountable to a higher authority than just the lawyers. Maybe it's the Bar Association collectively. Maybe it is the committee that de Blasio or somebody else heads in the mayor's office to make sure that there is compliance with this. Because remember, this is supposed to be for the public, right? He set this up for the public. The litigants, we were getting that information. We couldn't share the information, but we were getting the information.
Well, that's the key, because apparently, Newsday has been trying to get this information, so that they could reveal it to their, audiences, though their readers, if you will. And they're saying, wait a minute, why are we being prevented because of these, confidentiality orders, which in some cases are being, imposed upon the litigant, right? Because with respect to this article, they were talking about how the litigants that they interviewed are saying, no, this was imposed. This wasn't something I agreed to, because there may be some cases, right, where in most cases you may not want, you want to just get your info so you could get your client, represent your client adequately and do what you need to do. But if you have a client that says, hey, listen, I want everybody to know about this case. I don't care how long it takes. This is something that's a matter of public interest, and I want it to be that way. And the lawyer does too. Then,
and I think the argument becomes, and this is where we do it in the false arrest police cases all the time, right? People got to sit down and they got to carve that document out. Judge, I don't care about his name or address. I don't care about his address or his personal information. What I care about is his name, first and last, and what precinct he is. Yeah. You telling me I can't get the first name and last name and what precinct, and then the history? Then why are we here, right? Yeah. Now, if you want to talk about the personal information, I don't care if you live in Long Island, I don't care if you live in New Jersey. I want to know his name is Ricky Ricardo from the 45th precinct.
Why you got to be Ricky Ricardo, man?
Why not? Why not? Why not?
At least you didn't say Ricky Pichardo.
Oh boy. So look, while my signal is steady on that note, Ricky Ricardo or not, I think this is a good place for us to just highlight a piece of news that I couldn't share earlier. When you're talking about the DOJ and you're talking about all of these quandaries, we can't help but celebrate that maybe change is coming, right? Because we have had a historic moment, the first Black woman to lead DOJ Civil Rights Division. So this deserves a moment of observation here on the show. She's also a D9 member of Delta Sigma Theta sorority. So I know that those members are very proud, as we all are, as Black women and as members of the D9. So what impact, let's just insert a little comment, what impact will having someone like Ms. Kristen Clarke in DOJ do for situations that we have discussed on today's show?
To be quite honest with you, I don't know. I'm going to assume the better than the worse, right? Because we know that there are politics and everything that goes on. Now, I don't think that the Biden I don't think that Biden and his campaign and his administration is one that is going to fall prey to not moving the ball forward. But I would have to do a little bit of research on Kristen Clark background to see how she arrived and where she arrived. But one thing I do know is that, you know, hopefully she's seen the plight. I don't want to have tragedy beseech her, but, you know, hopefully she's seen the plight and is not vicariously, right? It's something that she can touch and see and have the experience, so she'll know what the masses feel and how the law is trending, such as this act, right? The Civil Disobedience Act that we're just talking about, right? How that is trending and how that is being used, or maybe used in a way that it shouldn't. I applaud her. I expect wonderful things, but I don't automatically think that things will just turn around.
And I think what, if I may, I think what Royce may be alluding to is the fact that the U.S. attorneys in the various districts around the country can sometimes operate in a somewhat semi-autonomous fashion, okay? And so there's going to have to be a certain level of respect there as well, that the U.S. attorneys around the country, especially in some of the more influential districts like the Southern District here in New York, and you know, the one in DC, and you know, in some other places, you know, hopefully, you know, because I also don't know her background, whether she's already in the DOJ or coming from the outside. How long has she been DOJ? What was her position? What was her track record and those sorts of things? How is she regarded by her colleagues? You know, all those things are going to be really big in terms of how influential she's going to be. So on that one, you know, you know, I'd have to know more. And I hope, I wish her the best.
And I wish her the best. I just hope that she has, and I'm sure this will come up on our show. What is the agenda, right? I always believe in human bites. You're going in there, you want to shake it up, you want to change things, but what is the agenda? What is the one or two things that you're going to change universally to make sure that justice doesn't become unjust for us?
Well, I appreciate that you're honest. We don't know what she will do, but we are excited that she is historically in this position. And I think Dee said, pray for the best, prepare for the worst. Yeah, it is quite a lot to factor in. Mr. Russell likes those kinds of commentary where Ed and I might still be springing with hope. But back into the conversation, that was just a little commercial break while I was steady here, because I didn't want the day to pass without acknowledging that this just happened. And it is a historic moment for us, as this is where the legal meets the cultural. So it is a cultural joy. But back over to you to continue on.
One of the things that I've realized in the conversations that we're having today, Ed, is that nothing is a sure thing, right? I mean, really, I just thought of it as we were talking, right? And even with what Dr. Grant put up, right, in reference to Kristen Clark, right? Nothing is a sure thing, right? And that's something to be reckoned with in a society full of humans, full of flaws, and full of laws, right? And so who would have ever thought that the Civil Disobedience Act would be used in this fashion? Not a sure thing, right? Who would have ever thought that when we open up 50A, that we wanted to get all the material that we could to educate society, right? And to basically, to a certain degree, shame officers into doing the right thing, right? But here we are. We have these confidentiality agreements that courts are trying to force down litigants' throats. Not a sure thing, 50A. And so now we deal with qualified immunity, right? Hey, it's struck down in New York. You know, there's some conversation about it going away universally under the George Floyd Act or whatever act that they're proposing in Congress and in DC, but it's not a sure thing. And tell me, Ed, why isn't it a sure thing? Why?
Well, a few days ago, or even a day ago, maybe, the Supreme Court denied the review two police misconduct cases, one emanating out of Texas and another one out of Ohio. In the Texas case, it's really a situation where you had a former law enforcement officer, former veteran. He apparently visits a VA hospital,
right?
Gets into some sort of discussion that turns into an altercation over the ID he had to provide. Next thing you know,
he had his ID in the bucket. He said, "My ID is in the bucket," and now,
which is always confusing, right? Because they tell you to empty your pockets and put everything in that damn thing, and then later on they're like, "Well, who are you?" Well, it's in that bucket right there, man. Right. And next thing you know, my man got hemmed up, and he had to get actual surgery.
All right, let me stop you there. Let me stop you there. For the legal minds out there, hemmed up means he got beat up. That means that means he got detained. I just want to make sure the legal minds out there don't miss that.
I would have put that in an actual complaint.
I think they got it.
That's the term that black lawyers use.
Really, Mr. Russell?
Hemmed up. So he got hemmed.
This is where the legal meets the cultural. They know hemmed up.
He got hemmed up. Right, so I just want to make sure, because there's somebody out there that's watching our show, CNBC, MSN, WNBC, whatever you name it, is watching the show, and they're looking for that word "hemmed up." And I just want to make sure that Black Law Dictionary, we got it. It's usually a him, and he's usually up.
And we don't mean in tailoring.
Black Law Dictionary. Oh Lord!
I don't mean his pants got hemmed. I mean the actual human being
is actually up. All right, so with
that my goodness. Well, thank God he's okay. Back over to you, Ed.
Yeah, so apparently, he suffered injuries that he had to get surgery on, and so he ends up, suing, these law enforcement officers, and the Texas court says, "Hold on, wait a minute, the civil." Yeah, the constitutional amendment you're using and the civil rights laws that you are trying to use maybe work for local law enforcement, but this is federal law enforcement. And so the standard is higher. It has to go under what's called a Bivens claim.
And let me tell you, Ed, the Bivens claim is so difficult. It is so extremely difficult to sue federal officers in the capacity for which they are working. And we all know the reason why, because that's the last step. That's the last door. We don't, America doesn't mind if you want to get the locals. You get the locals. You can get, Freddie with the toothpick in his mouth, or, Detective TJ, who's a bad cop. You can get them. We good with that. But when you step up and you coming after FBI agents, you coming after ICE enforcers, immigration customs enforcers, you coming after, the veterans, you come after those guys. Oh man, there's a whole, so the Bivens, Bivens, look it up, research it.
Yeah, and apparently, his case had gotten dismissed because the court said, well, your case is different. Bivens had to do with a private home and drugs. Yours has to do with a hospital and ID, and we think it was reasonable for them to ask for this ID. I didn't go through the whole decision. And so, I believe his name is Oliva, the plaintiff. He says, well, listen, I'm going to take this case to the Supreme Court. This isn't right. What does the Supreme Court do? They say, what, we decline to hear it. And once the Supreme Court declines to hear the case, that previous decision will stand. And so he is kaput. And then you had another case involving a gentleman who was, got into a physical altercation with police officers at his home in Ohio. And the court there granted the officers qualified immunity, claiming that their conduct wasn't something that was clearly prohibited by the law. And remember, we talked about at length on a couple of episodes ago about qualified immunity and the new law that was passed, in the New York City Council. So, this is this is disturbing because, you know, we already have a conservative court. You know, we already have these hurdles that we have to get over in terms of bringing these cases. You got the 1 year anniversary of George Floyd. This is clearly evidence for all activists, for all observers, for all those who care that we cannot sleep, we cannot stop, and that we have to remain ever vigilant and on the offensive. Because while we sleep, they plot. While we're playing checkers, they're playing chess.
And while
this is a big chess move.
Sleeping, they're thinking. So don't go to sleep.
Well, within reason, because somebody has to keep their beauty rest going. But I do want to say that what you just said, it went all the way to Supreme Court and they declined to hear it. Like, let's not let that get lost. That sends a whole lot out into the world because they declined to hear the case. Can we just go back on that where the legal meets the cultural?
Well, yeah, to the point, it's like doing, what's it, the cha-cha, slide to the left, slide to the right, crisscross, because that's what the Supreme Court did. Basically, these are issues that are being argued in society, whether in the courtroom or outside of the courtroom. And for the Supreme Court to bypass it, to say, we'll take a pass on that, it's just in and of itself. I mean, just quite frankly, to say that, we're not going to deal with these issues. And then we have to also understand that if there's any time to be litigious, is it any time to use your critical third eye, read in between the lines? Now is the time, because you have to look at what is being written and how laws are being decided and what the law is saying. So now we know with qualified immunity, for those who are not lawyers and not litigants, the word reasonable, you're going to keep on hearing it. Is it reasonable? Was it reasonable? Given the circumstances, could it have been reasonable? If you put myself in that police officer's shoes, was it reasonable for him to act? And a lot of times the answer is, if I was in that person's shoes with all the wherewithal that I had culturally and then some, I wouldn't have acted in that way, plus training. So, what's reasonable for me is not reasonable for you. And the word reasonable even becomes like a variable. It's not fixed anymore. So we have to really be mindful of not only whether a case is accepted, rejected, not only whether it is 5 to 6 denied, but what is being written in those denials, because that is the language that lawyers use to promote other things, right? They take what the Supreme Court has said in a decision and take 3 sentences from A and we go over to B.
And just to be clear, because we've talked about this on the show, I believe several times, and once again, just to be clear, what basically happens is that you have the right to appeal to a higher court. I believe in these cases, these litigants were appealing from those particular states' highest courts. And so right. Ohio Supreme Court, Texas Supreme Court, you get to go appeal the case to the U.S. Supreme Court. And so what happens is that the highest court, the U.S. Supreme Court, can agree to hear it, which is what they call granting certiorari, agree to review it, agree to look at the case, or they can decide, you know what, we looked at it where we decline to review. And once that happens, that means that decision will stand. It's kind of like, definitely the cha-cha here, because what the U.S. Supreme Court is doing in those instances is they're not saying that what the court decided was wrong or right. We're just declining to hear. But the problem is that in a way it's upholding it because
in a way they're
not deciding it.
That's right. Silence is an action.
Silence is golden. Yeah.
Silence is actually speaking. No action is actually action, right? Punting is actually saying something, and we need to recognize that. And for every action, guess what? There's a reaction, as I say. Right? And so there we are.
Yeah, and then what happens is in these particular states now, you got this decision. It wasn't granted cert. It wasn't successfully challenged. It's sitting there on the books. And now the next time something like that similar happens, boom, there you go. Because that's called precedent. And that can be dangerous.
I think one of the
Very
things
dangerous.
one of the things I would like to see before we move on, and maybe we'll even stay here, one of the things I would like to see is to find out how many states have an agency like the CCRB, Civilian Complaint Review Board. And if there are states that do not, why can't we make that mandatory, right? Why isn't there a certain entity or a distinguished entity that review cases like this? You can call it what you may, but I don't know if it's universally, established in every state. And so that might be a human bite that some organization take up, and maybe to make its way to our vice president or president, that should be something that is standard.
Well, at least at the very least on the state level, because of course I would imagine you're going to have local communities who are going to be like, well, we don't have any problems with our cops. We're not going to form no stinking CCRB. You know what I mean? And so you're going to have to make sure that you apply it on a state level where, listen, whether you create one or not, we're going to impose the one at the state level and investigate that incident in your local community. I mean, listen, man, I think a few years
you can have an agency where it oversees a number of counties, right? Right. So, that might be a way of doing it.
No. And what I was about to say was, even when you say you have it coming from the state level, you will still have local communities trying to figure out a way to get around it. Like, I think a few years ago, you had an incident, I believe, in Troy, where the local prosecutor, it was already after the executive order had been imposed by Cuomo, saying that these, police shootings, et cetera, similar incidents had to be reviewed by the attorney general first. And I believe in Troy, the local prosecutor decided, you know what? I'm not going to send this to the AG. I'm going to take this straight to the grand jury, get it knocked out of there, and basically poison the case. And so you will have local communities try to figure out a way to thwart these mandates, even when they're, imposed upon them. It's unfortunate. It definitely is unfortunate.
Well, it's one of those
Well,
things.
I think this also, if I could just add,
Go, please.
if you can hear me, one thing. So we talked about this on the show before about how many people were appointed in a number of counties around the country as judges. Like we're seeing how this continues to play out, where the legal meets the cultural. That's why you have to be aware of what's happening. The former administration put in a lot of people that we're going to have to deal with for another 15, 20, 30 plus years. So just rewind back to the shows. We've been talking about why this is important and why we really have to stay on top of what's happening. Like you said, they're playing chess and the pieces are moving faster. So, the pawns are going down, and we really need to see what's happening on the board and be aware as a community, especially with an election coming up in New York City, other places across the country, with positions that impact and affect what it is that we're able to get as far as justice. So just wanted to put that in there as a reminder. This is not new. We've been talking about this, but now we see how it reaches all the way up to Supreme Court and how that plays out when they don't decide to hear a case.
Now, this is something that we didn't talk about in the beginning of the show, but I do want to get both of you guys' reaction while we have a couple of minutes left, and we'll save the next story for another time, because this is a little bit more relevant to what's going on. Have you guys heard of, and what is your reaction if you did hear of, the Cuomo brothers, right? And how one is a commentator and influencing the other, and there's no repercussions whatsoever. And if we say anything on any TV or media outlet, off with our heads, and we have no jobs. Have you heard? Have you seen?
Well, I saw.
What you talking about, Willis?
Well, I saw a story recently where Chris Cuomo was apparently coaching his brother on how to handle the allegations that were being leveled against him
Correct.
And so, you know, I mean, listen, I don't know what more to say that other than to say, it's something that happens historically, right? You had Bobby and John F. Kennedy. I mean, when you have powerful families, you got the Bushes. I mean, it is what it is. Siblings, family is gonna look out for family. Now, where does that cross the line in terms of someone being very prominent in the media and the other one being a governor? Was that fairly reported? Well, it's gonna be an issue for the media company that currently employs Chris Cuomo, right? And then in terms of the governor, I don't know what to say about that in terms of the spin. I mean, he recently came out with a book. They're saying that he's going to get a handsome sum for that.
Well,
right?
I think money's never an issue with these type of folks, right? It's all about power and legacy, right? I mean, because if you're able to spend your life that way in public service, usually you come from a background where you are economically situated that happens, right? Or you find yourself in that lane. And I bring it up because I saw it hit the wire and then I saw it disappear. One day in and one day out. It was grand opening, grand closing. And we have seen our fellow brothers and sisters get fired from ESPN for doing less and saying less, right? And we know America's hypocritical, and race and color rules, right? But it's something that I wanted to share with the world, in that, at least on our show, that keep your eye on the ball. These are the things that happen behind the scenes. I consult with you. I'll meet you at the Nets game, or maybe I'll meet you at the Knicks game since they finally made the playoffs.
It's the Knicks, okay?
Do something, and then there we go. So
there we go. Must we bring basketball in it? But the question that you posed, Mr. Russell, I don't know. I plead the fifth on this one. I'm not sure how it's going to. I plead the fifth because I would hate to think that there was any impropriety happening there.
Yeah. Ed's the politician. He's up in Albany all the time. So,
I mean, listen. In terms of the media, they are who they are. I mean, when during a time when I was working for the New York State Senate, and you had David Paterson as governor, and you had African American leadership in the Senate, I felt like the media was relentless in terms of reporting any little perceived scandal, behavior, impropriety. They would go overboard to mention the smallest things. An extra Yankees ticket by David Paterson. I mean, things that would never get reported under a white governor, but it is. And in terms of the issues we talk about with this show, in terms of for the most part, a lot of the police misconduct and stuff, and just racist incidents that occur in this society, they aren't adequately reported. They don't have a sustained presence in the media. They're often forgotten. Right now, there's a huge amount of memory and tributes and dedications to this or that. But unless the activists keep this alive in people's minds, I doubt people are going to be talking about this, in the near future. It's going to be forgotten. That's why, it's so important for people to continue to talk about it, to continue to have the commemorations and the gatherings and the protests, to keep it on the front of folks' minds. Because, listen, during the civil rights movement of the 50s, 60s, early 70s, and then you had a lull during late 70s, throughout the 80s, and a good part of the 90s, where, incidents weren't really being covered adequately. You had a wave of conservatism around the country. So, and then, you got an incident like the George Floyd incident that seemed to have, woken up folks. And, Brother George was just the latest in a string of many others who had died and passed away. And then people started talking about Emmett Till, which was an incident that basically galvanized the civil rights movement. And once again, Emmett Till was
one of
at
many.
that time was one of many who had been lynched, beaten, burned, stabbed, genitals cut off, all types of gruesome incidents, that only the black media at the time was reporting. Chicago Defender, Amsterdam News, I mean, listen, 100 years ago, May 31st, Tulsa, Oklahoma, the Tulsa Tribune was the paper that reported this false narrative about this young black shoeshine boy offending this white female elevator operator.
Right, which caused the National Guard to come in.
Exactly.
Exactly. Wall Street and everything all over, right?
Yeah, the media has been historically complicit in, what goes on in this country, either over-reporting, under-reporting, or inaccurately reporting, on all sides. So, it's important that we continue to keep the media accountable, and even more important than that, us continuing to maintain our own media organs and telling our own stories like we're doing here.
And I bring this up partly because I knew it was something that was flip the radar and fall through the cracks. And I'm glad we had something to at least awaken, or at least bring to the surface to our listeners and viewers. The Como scenario, which brings us right back to, and I know we won't be able to do it today, but brings us right back to Byron Allen, right? We're talking about media, and here we are having our own platform, having our own space and time to tell our story, and we're right back here again. Byron is with us all day, every day.
Yeah,
well, we'll push a pin in it. We'll push a pin in it for next week to get into that, because we are at the top of the hour, and I thank you all for hanging in with me on the road as I celebrate my baby's prom. You only get one prom, it feels like yesterday was mine, so I don't understand. But thank you so much for tuning into the show. This was a good one, and clearly Mr. Russell and Mr. Pichardo had a little extra for lunch today. OMG. So we'll be back again next week, same time, 4 p.m. Eastern Standard Time. Thank you all for tuning in, being so active in the chat. D, Richard, Kevin, Brenda, everybody that's tuned in today. We appreciate you. And definitely, if you're catching a replay, just type #replay so that we know you were here. Stay safe and be well. And thank you for your support of Speaking Legally, where the legal meets the cultural. Bye-bye, everyone.